Hello everyone, my name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors based in Coventry in the United Kingdom. Today is the World AIDS Day, and we just want to commemorate the World AIDS Day. And as some of us might have experienced, we have got relatives, family members, friends that have been impacted one way or the other through AIDS or HIV. It is good to know and encouraging to know that treatment has been developed from when it was maybe in the early 80s, and further research is continued to be done when it comes to this area of medical problems. I am the current president of the Warwickshire Law Society, and as the president of the Warwickshire Law Society, my chosen charity that I am supporting is the Terrence Higgins Trust, which deals with people who have got HIV or AIDS. I chose this particular charity because of the fact that most of the people from the country where I come from, particularly Zimbabwe and Southern Africa, have been impacted or affected by HIV and AIDS. So it is something that is closer at home when it comes to me. So kindly support us if you want to support us, the Warwickshire Law Society. If you can make a donation, all the money that we are raising through this charity event or a charity donation is going to Terrence Higgins, which support people that have got HIV or have got AIDS or family members who have got HIV or who have been impacted by AIDS. So, in light of that, I just thought today maybe let me just discuss medical cases when it comes to immigration and employment. In terms of immigration, medical grounds can also be considered when someone is looking for leave to remain in the United Kingdom. The grounds for medical is not as easy, if I may put it that way, compared to other grounds. The threshold of medical cases is very high, and it's normally considered as under Article 3 in consideration with Article 8. And the case that has been historically used by the Home Office would have been the case of Annie versus the Secretary of State for Home Department. Although the jurisprudence have since developed from that case, but the threshold still remains the same. So where someone has got a serious medical condition or a serious medical conditions, it could be mental health, serious mental health, HIV or AIDS, serious heart problems, kidney problems, just to mention a few. Someone may use that as a ground to seek a leave to remain or a visa to remain in the United Kingdom. You have to have very good evidence to produce in your case if you're relying on medical grounds. And you have to prove that either the medication is not available in your home country, or if it is available, then it is very much expensive for you to be able to afford it to have a good life. It's a matter of comparing the standard of life that you might have or might not have because of the um, availability or non-availability of the medication that you might be having. So it's you might be having the medication here in the United Kingdom, but the fact that your life, the standard of your life, might slightly go lower if you leave the UK might not be considered. It has to be something that will severely impact on your health and severely impact on you. It is also important to consider that in light of Article 8, medical cases can also be considered that there are some people around you, your family or your friends or your community that might be impacted as well. So if you were giving care to people that have got serious medical problems or you're receiving care from family members and so forth, and you've built a rapport with your family or friends, or on that basis, the Home Office will also have to consider this. So Article 3 and Article 8 is a ground on which someone can get leave to remain, potentially using medical grounds. It is important to have expert reports. You might have a report from the doctors or the consultants that are treating you, or independent medical practitioners that might give you an expert report. And also, you might then need a report on your home country where the Home Office will be intending to return you to. So the expert report will you have to show that either the medication is not available, or even if it's available, it can be so much expensive that it will be prohibitive for you to have the medication, and your standard of living or your standard of or quality of life will have to go down because of the unavailability or the expense of the medical treatment or the medication that you will be expected to have to survive, so that your life continues. So expert reports are important from the medical staff, and also from a country expert who might also have to write a country expert report to show the circumstances in your home country. So another interesting area under immigration when it comes to medical conditions is the adult dependent relative. Um, if you are in the UK on indefinite leave to remain, or if you have got a British citizenship and you want to bring, say, your parents or your adult dependents, particularly your parents, really, you can do that under the immigration rules. Appendix FM for the ADR, adult dependent relative, and this is mainly considering parents that are now having to find it difficulty to do their own personal care, and they don't even want to care for them, and you've been supporting them, and if they come to the United Kingdom, you will be able to support them without recourse to public funds. And we are looking for people who are over the age of 65. So you can make an application to bring your parents from outside the United Kingdom under the adult dependent relative, and you have to show that they will be maintained without recourse to public funds. Again, you have to show that they've got very serious medical conditions and the medication is very expensive. You will be able to care for them in this country. There's no one else who will be able to care for them. So you need to produce the medical um, evidence of their ailments which they are suffering from. This type of application, you have to pay a fee to the Home Office. So you will pay some Home Office fees as necessary. So adult dependent relative is another one that considers the medical condition of people. Again, there are some people who are outside the United Kingdom who might want to come to the UK to obtain private treatment on a short-term basis. So, and if you want to come to the United Kingdom for specialist treatment, or you've got your doctor who's in the United Kingdom, you can get private treatment, a standard visa, a medical visa for up to 6 months, or it can be 2 years or 10 years. But when you come, you have to come for 6 months or less in a particular period, and you have to have a letter of support from the doctor or the consultant that you're coming to the UK to treat you, and you have to prove that you've got enough income for you to go on the treatment on a private basis here in the United Kingdom. So, in terms of immigration, I've touched on three grounds. The first one, medical grounds under Human Rights, Article 3 and Article 8. The second one, adult dependent relative, when you want to bring your adult relatives to the United Kingdom. And the third one will be if you want to access private treatment in the United Kingdom, if you can afford to come to the United Kingdom to get private treatment on a short-term basis, then you can make an application with the support of your consultant or your doctor who will be going to attend to you. When it comes to employment law, again, some people get stigmatized because of their medical conditions. It used to be that some people would stigmatize people who have got particular ailments, or you are victimized because of a particular ailment that we have. It might be mental health, or it could be because you are considered disabled, or you have got things like HIV and so forth. Some people are treated unfairly, and it is important to know that if your colleagues or your employer is treating you unfairly, or they are victimizing you, or they're discriminating you, there is a recourse in law, under employment law, in which you can seek redress. It could be for compensation, or it could be just to have the people who are treating you to treat you in a fair and better way. So under employment law as well, you are protected. There is also some protected rights for people who have got certain medical conditions under employment law. So if you are suffering at your workplace, or if you are being victimized, or the workplace is refusing to make necessary adjustments for you because whatever reason they are, then you might have to approach them, raise a grievance, or if they do not deal with your grievance, accordingly, you can then go to ACAS, a mediation organization, so that you can try to mediate. And if ultimately there's no resolution, you might then also then have to go to the employment tribunal. It is important to note that under employment law, there's some strict deadlines that you need to observe. So you need to consult a lawyer who specializes in employment law, so that they can assist you with your case at your earliest convenience, because your case has to go to the tribunal 3 months less one day. Otherwise, you cannot be able to then take it to the tribunal. Some of them might be three months less one day from the date of dismissal, or from the date when the act that is complained of, such as discrimination, it will be some things that needs to be um, taken as soon as possible. Otherwise, you will be out of time. At Tanlaw, we have got solicitors and lawyers that can help you in immigration or employment. And if you have got any questions, you can contact us using the details that are on the screen. And thank you so much for watching. And again, my name is Andrew Yamaro from Tanlaw, and we will be meeting again next week. Thank you.